Unfortunately, one of our presenters, Kahle, is unable to be here today because of some unforeseen circumstances that came up. So Professor Fritze has generously offered to man the floor by herself. So
I don't know about that.
I know. So she will be discussing class action and mass tort cases. And you've heard from her earlier, but let me just introduce her again, Miss Professor Fritze.
Thank you. This thing is not, is this on? Is it on? Yes. Okay. Karen and I had split this up, and she was going to present a portion, and then my half was more on the class certification hearing, a little bit about North Dakota. This is her presentation that she emailed me to, and she really did have an emergency that she couldn't avoid. She didn't just bail on me. So we'll see how this goes, because I haven't really had a lot of this happen last night. So the first half of it is going to be maybe a little cryptic, but we'll get through it. So let's see what we have here. Class actions for oil and gas lessors. And by the way, she tends to represent producers. In my other life, I tended to represent royalty owners. Did represent some small producers back in the early 90s, but the last 10 or so years was all royalties. So this morning was my producer side on the Migratory Bird Act. This afternoon is my royalty owner side. So if I tend to go over in that direction, you'll understand why. If you represent producers, then what you need to take home is whatever I say about what a royalty owner should do, then that's how you defend. That's the way you go after them to defend them. So anyway, so hers is kind of tainted a little bit more that direction, as mine will be the other. Okay, she starts off, and she did this in a very basic form. I know that some of you guys have been practicing for a long time. Some of you may never have done any oil and gas work at all, and just trying to find out what it's all about. I don't know what the mix of this is. So if you have a lot of experience, just bear with us for a little bit. We'll get into some more things that kind of apply for either group. So we're going to go through some basics of what is a royalty a little bit. The basic concept of a royalty is it's a non-working interest of the lease. So you owned it all. You gave away the rights to drill and to produce. You took a bonus and you kept a royalty. Maybe it used to be a 1/8, then it went to 3/16. I think out west some of them are now getting a quarter, because we know what's there, and the royalty owners are getting more savvy. So they're getting less, maybe less bonus, maybe not, and then getting more on the royalty side. So it's a nice place to be if you good work if you can get it. But the other side of that is what the royalty owner has given up is they lose all the rights to make the decisions about how that lease is going to be developed. And so they are relying on their lessor, who then joins up typically with a bunch of other lessors and to form a joint operating agreement, or in some instances to be pulled or spaced, compulsory pulled or spaced. And in the end, you all end up together and to produce a well or group of wells. And this is also changing the whole idea of how all these concepts that I'm talking about, with the hydraulic fracturing, with the lateral lines being so long, you're going to have larger groups under the well just by nature of the beast, which is then going to create an issue that would perhaps lend itself into a class action if the production for some reason is not correct, there's not enough costs, whatever. So the royalty is non-working. It can be in kind. It's usually paid in cash, but there is the right to take it in kind. Okay, so we're going to talk a little bit about this. This is where the issue really gets the heat, is where do you value the gas? Some of the common lease language that you find, and I pulled these off just real quickly. in different leases. And this is always in a class action. This is going to kind of jump back and forth between mine and hers a little bit. But in class actions, one of the first offenses is always, if you have a group of royalty owners, is the producer is always going to say, well, the leases are all different. We can't have because there's all these different lease language. And that has been, in most states, that has not prevented judges from certifying classes. But this is some examples of what different lease language might look like. You might have, and I've just pulled out the language is much longer, but you might have a gross proceeds lease. You could have a proceeds if sold at the well, or if marketed by the lessee off the lease premises, then market value at the well. What the heck that means. You may have, it just says proceeds. Could say value of the raw gas at the mouth of the well. And some of them say net proceeds. And even though there's several different versions of what the language, I've analyzed it down, and I think the last class action that I was involved with, which is still ongoing, is a 3-state class action. It's Texas, New Mexico, and Oklahoma, certified in Oklahoma. We have separate classes for Texas, Oklahoma, and New Mexico because there are different laws. And we went through and were in the process of analyzing the language of all the leases in our test wells. We had a group of wells because we're talking thousands and thousands and thousands of wells that would be involved in this case once it was certified. So, and when you really start analyzing them down to really pulling out all the extra phrases, they break down into about 4 or 5 basic, in my opinion, 4 or 5 basic. And judges have routinely in states that go ahead and certify even with differing lease language. What has happened is it might be more successful if the operators were paying by the lease language, if they were distinguishing in their payment systems between gross proceeds and net proceeds. But they historically have not. They have one accounting system. Everything goes in, everything comes out. They all look the same. So that's where they've gotten in trouble and given the ability for the royalty owners to come in because they're talking out of 2 sides of their mouth. They're saying these leases should be, we shouldn't certify because these are contracts and you have to read each one and you have to determine damages based on the exact language of this lease. Oh, but by the way, we don't have to read them to figure out what we owe people. So, they really have had a hard time with that in some of the states. Some of the states do, there have been. In fact, one in Oklahoma, just Judge Friot in federal court I've got it here, denied certification. Part of it was the defendants did a really good job of just throwing all these different lease languages at him, and that was one of the reasons he said, no, we're not going to certify. So these are some examples of the language that you would find in the older leases. I think newer leases are more uniform, and if you on a horizontal unit, if you've got a big player, like up here you have, Continental, big player, they're going to have leased a lot of land through their representatives. So the leases may be more consistent. And as the leases have evolved, the language has kind of gotten less and less differences. So that's one of the issues that always gets brought up in class actions is this different lease language. So here's, from the producer's side, it costs money to find gas, get it out of the ground, process it, and transport it to the end users. So who should pay? From the royalty owner side of the argument is, I gave up 7/8 of my lease. I have a non-cost bearing interest. You get 7/8 of the production. I was supposed to have, that's what you promised me, a non-cost bearing ride. So those are the 2 sides of it. The first principle there is, it's universal that the cost of bringing the product, and today we're talking, this is kind of ironic, we're talking mostly about gas in North Dakota. which is going to become more and more of an issue, and I'll talk about that a little bit later. But the lessee is responsible for getting the product to the surface. That's the non-cost-bearing portion. The royalty owner has no obligation to pay any, unless they participate, unless they decide not to sign a lease and participate. But if they sign their lease, give their lease to Continental drills. Continental is, for part of the bargain is, you don't have to pay any of the cost. So if I drill a dry hole, I have to foot the bill for that. And that's no small number with these horizontal wells. Of course, seismic's gotten so good and the science is so good now, I think that's less and less of a risk. But that's the bargain that royalty owner made, is that I'm not going to pay any of the costs. And for that, I'm going to take this smaller portion. This at the well language, how's it going to impact post-production costs? Now, once we get it up out of the ground, that's where all the litigation is as far as royalty owners. You do have class actions with working interest owners. You do see those. You see, disputes between joint interests, people who are non-operators of the well arguing over what costs were expended in drilling the well and what are what those costs are. But I'm really kind of zoning in today on royalty owners. So we have to decide what this at the well language, what does that mean if you've got a product, the gas comes up out of the ground at the well, but there's no market at the well. You're not selling it at the well. You've got to take it down. You've got to process it. You've got to move it off the lease. You've got to get it into a pipeline. It may have hydrogen sulfide in it. You may have to take, you have to do some processing. Who are going to pay those processing costs? And that is where the crux of these class actions lie. And so we'll talk about that in a little bit more too. And then there's the implied covenants when the lease is silenced. The implied covenant to develop. It doesn't say you're developed, but that we know that was what the lease was written for. And so there's this implied covenant that you're going to go out and develop this lease prudently and economically and for everybody's benefit. So that's the implied benefits. Okay, the process. The standard lease, and if I hadn't been in touch with this in a while, so to know, this is a good question I have to ask. Is I believe that leases are becoming more standardized, and the guys that are out there, they need to be. They'd be a lot less trouble for the operators and for the producers if they would use standardized leases. They don't always have control over that because you've got landmen who, for a living, go out and lease and then assign their leases to someone else. They never had any intention of drilling a well. So, they go out and probably less of that with these big bonuses up here. But in times when they'll go out and they'll buy leases up and then they assign them and they keep a little portion back for themselves. They keep what's referred to as an overriding royalty interest. And so that's how they make their money, is going in early, buying up leases, and then cycling them through. So Continental has no control over who goes out into the Bakken and leases land before they get there. That's why there's so many landmen out there trying to lease it up. Lessees agents take the leases. Lessees can take assignments. Then the next step is you have some development. Once the gas begins to flow, you've got to gather it, process it, transport it, and then the royalties are paid once it's sold. And so that's kind of her 5 steps to getting the product to sell. Disputes over royalties. These are some of the typical ones. Improper deductions are always a huge portion, and those are more for states like Oklahoma. Improper deductions are huge. States like North Dakota, Texas, not so much. And I'll talk about the Marketable Product rule, and that kind of explains the difference in a minute. But that's kind of the deal, is that even if you can have deductions, from the gas once it comes up out of the ground. You still have the issue, was it the right amount? Can you take, what you can take and how much you can take are still issues to be that will be litigated. If the lease language is silent, that's what I was talking about a minute ago. How the lease terms are interpreted by jurisdiction, the covenants, how are these different gross proceeds at market value if sold off it goes on, and I mean there's pages and pages of these different ones. So if it's a net proceeds, a gross proceeds, raw gas at the well, how do we come up with what is that value, and where do you value it? Do you actually value it at the well, or do you value it further on down? And if you do you get to charge the expenses between the well and when you hook up with the interstate pipeline? You have to go through. You sell it to a gas processing plant. One Oak is building a new processing plant. I think they were supposed to start in April, out in the Bakken. So we're going to see some more gas being processed. So if you sell it at the front of the gate. Sometimes it's sold at the tailgate. So all these issues of where the gas is sold become issues on how you value the royalty. This is her little point on be proactive, avoid disputes. So if you're advising clients or have about new leases, try to make those points of valuation clear. If there is if a company develops a form, make sure that form is being used, because if somebody pulls a packet out of a cabinet and it's an older form, then there you go. You got different forms, and then you have to figure out what are we going to do with those different forms. If you're dealing in an area with a lot of old leases, Oklahoma has a lot of old leases, Texas has a lot of old leases, then you have to understand the different laws about how those leases are going to be interpreted and between jurisdiction. Texas and Oklahoma are two really good examples because they're diametrically opposed on one of the primary issues in class actions, which is the marketable product rule. And then transparency and calculation, and I'm going to talk about that a little bit more when I do my part on the check stubs, because that's another issue, an area that companies get in trouble a lot, is what they put on their check stub. So what does market value at the well mean? And this first marketable product rule. Oklahoma has the first marketable product rule, and Texas has rejected that, and North Dakota has rejected that. And what that means is that you cannot begin to charge expenses to the royalty share of the gas that is produced until you have a marketable product, i.e. a product that you can put into the interstate pipeline. So if you have to take hydrogen sulfide out, if you have to compress it to get the right pressure, if you have to take liquids out, whatever you have to do to get that product into a marketable state, in Oklahoma, those cannot be charged to the royalty owner. In Texas, they can be. They don't follow the first marketable product rule. So in Oklahoma, there's been some really nice lawsuits over the marketable product rule, because, as I said, nobody paid attention and calculated anything different on a gross proceeds and net proceeds. They just did it across the board. And since that question is always there in Oklahoma, is this marketable product rule. So that is probably the number one ticket item in my experience. And I've been these class actions for oil and gas royalty for about 20 years. We had, through the years, there's been other issues, but in the last 10 or so has been the marketable product rule. Has given a lot of fodder for attorneys in Oklahoma and in those jurisdictions to file class actions. And then again, I'll talk a little bit about this in the next section of the what acts or omissions support a punitive damage award. Can you get punitive damages when your basic instrument that decides the relationship of this operator and the producer and the royalty owner is a lease? So, and yes, sometimes you can. It depends. Isn't that a good answer? Isn't that the answer lawyers always give? It depends. So this statement is absolutely true. There's no agreement. We have a majority of states that appear to be following the marketable value rule, although I think if you look at the states, it's not necessarily quality, it's quantity. The eastern states are tending to go towards the marketable product rule, but their production historically have been less. North Dakota just recently went and decided that the marketable product rule does not apply. So that's a big. You have Texas and North Dakota. Of course, this is gas again, but we're going to see some gas. There's gas being produced. We're going to see a lot more gas produced in North Dakota. It's coming. And then this netback calculation is when you have that's what states such as Texas, North Dakota, they allow a net back. They allow you to, because you didn't sell the product at the well. So whatever expenses that you incurred getting it to the interstate pipeline, then you can that's the value you take, and then you net it back. So whatever you sold it for, you just back it out. That's what the net back process does. There are even in Oklahoma, you are allowed to take certain costs once you get it to a marketable state. So you can take transportation to get it at some point. You may not be able to take it from the lease to the gas processing plant, but from the gas processing plant to the interstate pipeline junction, you would be able to deduct those transportation costs. So it's not that you can't deduct any costs, it's when can you start deducting costs. And of course, they always have to be reasonable, regardless of whether in any state. So this concept of a marketable product is based on this covenant of duty to market, that you diligently seek a market and obtain the best price, and it's based on the idea that, again, as I explained earlier, it's the royalty owner is the non-cost bearing. You gave up your rights to decide how to develop your minerals, and you took back a small portion of the royalty in exchange for that. And so that's the basis that states like Oklahoma have hung their hat on to determine that that's the rule they're going to go with. So her section on punitive damages, and I really don't say much about it, but in the other side, if you have fraudulent concealment, which would be, I'll just go ahead and put it here, and then we'll jump on it when we get to the other side. The check stubs, historically, again, companies had done a really poor job of complying with the check stub statutes. And even if there wasn't a check stub statute, what they put on the check stubs. So if you've always, forever and ever, there's always been a column that says deductions. And over in the 70s and 80s and 90s, it would just be blank. Well, if I just receive a check stub and it says 0, then it's fair for me as the royalty owner to assume that there were no deductions. Au contraire. The way they calculate when they do their accounting, they take all the deductions out, and they have their rhymes and reasonings for it, which they are able to explain. But they're actually saying from the point that I had to tell you, then I didn't deduct anything after that. And they'll show the taxes deducted. So there are some deductions. So, if you relied on these on these check stub statements to determine whether you had a reason that you were put on notice, then it would be fair to say 0 means 0. So that forms a basis for people getting into the tort issues. That's one of the bases. Another one's the fiduciary duty. I'll get to that, and I don't think she has that in hers. So you don't often see these punitive damage claims go all the way out and get an actual trial, because most of these cases settle. So they settle after at least one appeal, after several appeals, but after the class certification appeal. So you don't often see a punitive damage award. There was one against Kaiser Francis in Oklahoma. He took it all the way as far as he could and lost all the way, and it was affirmed. I think he even tried to take it to bankruptcy court, maybe. That's been several years. But that's the only one that comes to mind. But it does give you a basis that you can get everybody to the table and talking, because when you start talking punitive damages, then you're beginning to talk numbers that nobody wants to have to pay out, for sure. It's one thing to have to pay back something that you already took, but it's another to have to give up money that you really was never in the deal. This is a list of the states that apply the first marketable product rule. This West Virginia, and I have to be very frank with you. This is this Taney case. I'll give you the site if you're interested in looking it up. It's Taney v. Columbia Natural Resources, 219 West Virginia. That's actually a southeast. 633 Southeast 2nd 22. That's a 2006 case. And she lists it as the most extreme. So I think Oklahoma's pretty liberal. And I believe what the case says is that there's no deductions at all until you've sold the product. So if you have an interest in looking that up, you can look that up and decide if, in fact, West Virginia is the most extreme. Colorado, Kansas, Oklahoma, Arkansas. There's a Utah District Court case that seems to indicate they might recognize at the well. Marketable product rule. Texas, Louisiana, Mississippi, California, Kentucky, Montana, New Mexico, and North Dakota have all rejected it. So, it's still like there's a debate on whether who really does have the majority in that, because I think the majority is the non-marketable, but in volume, it definitely is. By volume of product, it definitely is the non-marketable product rule. So here she describes the at the well means post-extraction costs may be deducted. That's these are the states that have rejected it. So these post-production costs can be taken before you pay royalty. And that's the list of the states that, and Texas being the leading gas producer there, that has rejected it, and now North Dakota. Always have to remember it's gas, though. So here's, she's showing that this is a recap on what you can do to kind of save your client to get back, so we don't have a class action. Class actions are really expensive, very long and time consuming, and nobody's happy at the end, except maybe the lawyers. That's not true. That's not true. My clients, we had some pretty happy clients, but but nobody's happy at the time. They take 10, 12, 14 years. You lose your life for a long period of time. So, do language, look at your language, use it consistent. If you have anything to say about what leases are going out there, pay attention. That was the problem. No one really, in the early years, no one really paid attention to that clause. We just were out there leasing as fast and as hard as we could. And so pay attention to what the lease language is and what might be the ramifications of that in your jurisdiction. Know what the old lease language means. You may want to tell your client you need to pay people differently. They're not going to want to hear that. But by and large, if they're using old leases and it's a big area, that it's going to be true. And then, as I said with check stubs, if it's my firm belief that if these companies had been putting those deductions back in the 70s and 80s and early 90s, if they had put the numbers, 70s and 80s, at least it would have told the statute of limitations. And that's the other issue you get into, is the discovery rule. And I'll cover that here in a minute. But if you have transparency and you put down the information, I don't think that the people who ended up suing in the 90s and got to go back to the 70s and 80s would have sued in the 70s or 80s if the lease language had been on there. And so they would have at least started a statute of limitations and put people on notice. So transparency is really a big deal on a check stubs. That's your really good way of communicating and setting up a situation where you're going to at least tell the statute of limitations and end up with a contract statute instead of a tort or discovery. More importantly, a discovery statute is what you end up with.